Welcome back to One Stop Law. Now, in this video, we look into another very famous legal maxim, that is Res Judicata. The legal maxim Res Judicata means that a matter is already adjudged or a thing is already adjudged. So, according to this maxim, a suit or a dispute in which the matter directly or substantially in issue has already been directly or substantially in issue in a former suit between the same parties or between parties under whom they or any of them claim has been decided by a competent court shall not be tried again in the same matter in any other courts. So basically it means that the parties are same and the dispute between them is same. The matter has been decided previously by a former court having competent jurisdiction over it. Then the same dispute can never be taken up between some other court of this parallel jurisdiction when the parties remain same and the dispute remains same. So basically, res judicata means a matter finally decided on its merit by a court having competent jurisdiction. So very important is this point that the court which decided the matter previously must have jurisdiction over it. If it did not have jurisdiction, then res judicata will not apply on it. But if the matter which was previously decided by the court had jurisdiction over the matter, then this matter will not be subjected to any future litigation between the same parties in some future courts, in some other courts in future. So in simple words, a decision once rendered by a competent court on a matter in issue between the parties after a full inquiry should not be allowed to be agitated over again by the same court or some other court between the same parties in the same matter of some parallel jurisdiction. Let me give you an example. Suppose A had filed a suit against B in a district court of any state regarding some possession over some property, and in that matter the that particular district court had given the decision in favor of A. So now B has practically lost that case. So now B tries to again institute a fresh suit or litigation in some other district court in that same state over that same property dispute against A, because he is not satisfied with the previous court's judgment. Now, in this case, the maxim of res judicata applies, since the same matter in the same suit, again the parties remain same between the same parties A and B, was already decided by a court of having competent jurisdiction earlier. Now, if we look into our Indian law, in India, this principle of res judicata has been promulgated under Section 11 of the Civil Procedure Code of 1908, which means again that a thing decided or a matter is finally adjudged, and it can apply in a case where there has been a final judgment. So basically, the rule of res judicata means the rule of conclusiveness of the judgment. Basically, it states that judgment of a competent court should be conclusive on the merits if it had jurisdiction over that matter. So the rule of res judicata means the rule of conclusiveness of the judgment as to the points decided by a court of competent jurisdiction, either or on facts or of law, or of facts and law both. In every subsequent suit between the same parties, it enacts that once a matter is finally decided by a competent court, no party can be permitted to reopen the same matter in a subsequent litigation. Now, if we look into the essentials to constitute a case to be barred by res judicata, what are they? What are the prerequisites? Number one, there must have been a final judgment. So the matter which is to be barred by res judicata in the future case must not be pending or sub judice. Rather, that should have been decided finally by the previous court, and that is a final judgment. Number one. Number two, that judgment must have been given by the previous court on merits of the case. Number three, the claims must be same in both the first and the second proceedings. And last, number four, the parties in the second proceeding must be the same as those in the first, or it can be their legal representatives only. So the parties should also be same, or the parties are just the legal representatives of the parties which were in the previous suit. It's the same parties, same cause of action, same matter in dispute. They are trying to reopen it in another court of parallel jurisdiction. Like I said, one district court decided the matter, now they are trying to reopen it in another district court. So it is barred by res judicata. You can only go on appeal to some higher court, but you cannot disturb continuously courts of parallel jurisdiction with same cause of action between same parties. Then what will the court doing with other cases? When will they hear the other party's case? So that basically takes us to the objects of res judicata, what it tries to aims at. Basically, res judicata aims to prevent injustice to the parties of a case that has been supposedly concluded. So like I gave you the example, in the district court, the matter regarding that property dispute between A and B, the matter was decided in favor of A. So B has to either give respect to that decision, or who could have gone to appeal to some higher court. He cannot simply say that I will not obey this court's decision and I will go to some other district court. So that would have been injustice to A, in whose favor the court has ruled. So to prevent that injustice, number two, to prevent unnecessary waste of time of the court or the resources of court, they have other matters to look into. Third, to prevent multiplicity of judgments, to prevent multiplicity of proceedings between same parties on same cause of action, the doctrine of res judicata is important. And last, to prevent recovery of damages from the defendant twice for the same injury. Okay, so you cannot have, for one cause of action, you cannot have to twice, you cannot recover the damages two times by instituting two separate suits in two courts of competent jurisdiction. So yes, that's all for res judicata. Till I see you in some other lecture. Thank you all.